Just a friendly announcement that we are now live on the internet. Good morning, Kavita. Would you like to do a mic check?
Good morning. Can you hear me?
Yes, I can. Thank you. Good morning, Vice Chairperson Wasserman. Would you like to do a mic check?
Yes, Mike.
Mic check good. Thank you.
Thank you.
Good morning, Matthew. Would you like to do a mic check?
Sorry, I have a slow mouse. Testing.
Testing sounds good. Thank you so much.
Thank you.
And good morning, Bruce. Would you like to do a mic check?
Good morning, everyone.
Good morning. And Chairperson Ellenberg, would you like to do a mic check?
Good morning.
Good morning. Thank you. And Dave will be your clerk for today.
Okay, thank you. Good morning, President Wasserman.
Good morning, Vice President Ellenberg.
Let's see, I think we still have a minute or two.
Yeah.
Two, in fact.
All
All right. Good morning,
Recording in
everyone. We are
progress.
at 10 a.m. on Thursday, May 12th, 2022, and I'm calling to order this meeting of the Public Safety and Justice Committee. Let us start with a roll call vote, please.
Good morning, Vice Chairperson Wasserman
Here.
and Chairperson Ellenberg.
I'm here. Thanks,
Thank
Dave.
you.
Item 2 is public comment. This portion of the agenda is set aside for members of the public wishing to speak on matters not on today's agenda, but within the purview of this committee. Do we have any speakers today, Dave?
Madam Chair, I currently do not see any hands raised.
All right, then we'll move on to item 3, which is to approve the consent calendar and any changes to the agenda. And Supervisor Wasserman, my recommendations are to add item 10 to consent and to hear items 8 and 9 together.
Sounds good. I'll second that motion if that included number 12.
It does, and I'll just, for the public survey that Sunshine, what is the item that we just put on?
Item 10,
Item 10.
the county exec food programs.
Hang on one second. I just want to read it. Make sure I'm hitting the right number. Yes, item 10 is the food programs and nutrition at other jail facilities that we are moving on to consent. Thank you. Do we have any speakers on consent?
We have no speakers. Oh, my mistake, Madam Chair. We do have one speaker. How long would you like to give them?
All right, 2 minutes, please.
All right, one moment, please, while we get the timer up. The next speaker is Ted. I'm unmuting you. Please accept the unmute. You'll have 2 minutes to speak. The timer will start when you begin speaking.
Good morning, supervisors. My name is Ted Scarlett, and most of you know who I am. I've spoken in the past of my concerns of Jeffrey Francis Rosen. It's my opinion he is unfit for office. I am very concerned about his interference with the 2 candidates that are running against him right now and believe he should be disqualified in this election as a result of his actions. Rosen has been prosecuting me, a malicious prosecution, for 7.5 years, 148 hearings. The accusation is recording a false document. The document in question is a quit claim deed. I've gone to over 30 defense lawyers. Every one of them is dumbfounded and have told me that this is not a crime. Under any circumstances, a quit claim deed is a release of interest in a subject property. It releases only interest that you have. If you have none, it releases none. This is not a crime. Again, he's been maliciously prosecuting me for 7.5 years. He's caused me 2 heart attacks, the second one in the courtroom. Also, I was threatened for simply trying to file criminal charges on the individual that removed the entire contents of my home of 32 years. And I was threatened. I was also threatened by one of his DA prosecutors for bringing up the fact that they put in writing that if I would drop my civil lawsuit for my home, they'd drop the charges.
And that concludes our request to speak.
Thank you very much. Supervisor Wasserman, would you like to make a motion to approve the consent calendar as amended?
Yes, 12 and number 10, my motion to approve. Thank you.
And 8 and 9 to be heard together.
And
I guess that's not consent.
no, that's all right. I seconded your motion
Okay.
previously, so that is my motion.
Okay,
Madam
great.
Chair, I'd like to make a motion. Could we please hear 8 and 9 together and put 10 and 12 on consent?
I will second that motion. Let's
Thank
do a roll call vote.
Vice Chairperson Wasserman
Yes.
and Chairperson Ellenberg.
Yes.
Thank you.
Thank you very much. Moving on to item 4, which is an update on alternatives to incarceration work group. I'm going to turn to Martha today and request an update from administration on the status of the informal competitive process.
Thank you, Supervisor. Just very briefly. So we are currently in the evaluation phase of the contracting process. We have an evaluation team of 3 county staff who are subject matter experts, but we also invited a member of OCLEM to sit on the evaluation team. So that was going along quite well. We anticipate having an agreement finalized by the end of May. This is a little bit later than we originally told you because, as you recall, last month when I reported here, we decided to push the due date out a few days in order to get respondents time to address some of the answers that we provided to the questions in their proposals. And so again, we're still aiming for finalization by the end of May.
Thank you very much. If that's the case, I'm going to anticipate a start date of the ATI work groups in August, since end of May probably makes a June meeting a little bit unlikely, and then a lot of county staff is off in July. So I'm going to reconnect with all of the expected members of the work groups and let them know to expect an August start. Thank you very much. Supervisor Wasserman, do you have any questions on item 4 or anyone
No,
else
ma'am. Thank you for the report.
on the screen? All right, we don't need a vote, but we do need to see if we have public speakers.
We do have one public speaker on this item, Madam Chair.
All right, let's do 2 minutes, please.
Oh, it looks like that person has lowered their hand. My apologies. We don't have any requests to speak.
All right, then we'll move on to item 5, which are monthly reports on efforts to reduce the jail population and court backlog. And I think today we are anticipating a verbal report from Casey Helka.
That's correct. Good morning, Chairperson Ellenberg, Vice Chair Wasserman, and members of the Public Safety and Justice Committee. Today I will be leading the item, and first we will hear from the Office of the District Attorney.
Good morning. This is David Angel from the District Attorney's Office. Thank you, Casey. Good morning, Supervisor Wasserman and Supervisor Ellenberg and the other members of it. I thought I would take a moment this morning to highlight the efforts we're making concerning narcotics charges, in particular, a little update on the narcotics public safety policy. As you may be aware, our office probably has the most expansive diversion program for narcotics in the state and arguably in the country. And essentially what the policy is a little different from other forms of drug courts and other forms of diversion, because the goal is really to redirect folks entirely out of the criminal justice system when they have been arrested for what we call recreational drug charges, but really that's probably not the best term, because for many of these people, their drug problem is not recreational, but a true public health problem. But essentially, we're trying to distinguish between things that we think have a public safety component, to which naturally the DA and the courts have an interest, and those which really are more an individual or family or community health problem, to which we think enmeshing people in the criminal justice system actually makes it worse. And it's, of course, a very expensive remedy as well. So the policy that we have is that if a person is arrested for basically any of the basic personal use drug charges, including possession and being under the influence or paraphernalia, previously those people would be arrested, they'd be charged, they'd be brought to court, and then they would be diverted. The problems that this brought was it was still enmeshing people in the criminal justice system. Many of them wouldn't come to court. They'd begin their diversion process. They wouldn't often complete it. Those then ended up with bench warrants. Those people end up in jail. Not all of them, but a percentage of them. And since it was such a large number, that really was driving the short-term jail population. We did look at our data, and we determined that if we limited charging to people who had 3 or more arrests for any one of the drug charges within a 12-month period, we would eliminate 95% of all the filings. The logic behind this was that if somebody's addiction was so strong that they were being arrested over and over again, that this was a proxy for someone who was probably going to have other collateral behaviors that would have public health, public safety and public health associated with it, and at the same time it would remove about 95% of our cases. That's been our policy, and I asked for an update on that yesterday, and we have, since the inception of the policy, which was in late 2019, we have diverted out of the criminal justice system about 14,000 individuals. So that's just a huge number. And so you can imagine, even if it's only 20% of them who had some failure in their diversion work, which didn't show up to court or something else, that's a lot of bench warrants. That's a lot of people not spending, even if it was just a day or two in jail. That's a big number. I do want to assure people that we work collaboratively on this policy with our other county partners. And I want to thank them for a moment, behavioral health, public health, and then our various public defender and other defender organizations. Because what we do when we get those cases is we send a letter to the last known address of the defendant, which should be fairly accurate because they've just been arrested. And then we tell them, we're not going to charge you, but this may be evidence that you have a drug problem, and we encourage you to contact these county numbers. Our partners at the public defender, ultimate defender, and so on, they also get notified, and they separately make efforts to reach out, because knowing that there's some people who can respond a lot more positively to a letter from the public defender than from the district attorney. And we similarly share the information with behavioral health so that they can do their own outreach efforts. And in this way, we think it's actually going to reduce crime overall, because these problems will be addressed up front instead of being addressed months, if not, a year later when the case finally resolves. So I can answer more questions about it. And we're continuing to study it. I do want to say we did consult with the Drug Policy Alliance before doing this. And when I reported back to them about a month ago, they laughed and said, we had a huge ballot initiative, I think it's in Oregon, where they managed to decriminalize all manner of drug charges altogether. And they pointed out that our county had diverted more people in our policy than the entire state had after they had changed the law, because anytime you change the law, there's a lot of exceptions and carve-outs. So we do consult with them regularly to try to get information from different perspectives. But I think that's had a indirect but very significant role in reducing our jail population.
That's really fascinating, David. Thank you. Supervisor Wasserman, you have a question.
Thank you, Madam Chair. ADA Angel, the 14,000 I missed when I was writing it down, over what period of time was that?
That would be since I asked the same question, and it would have been from the end of 2019. I'll note that, like any program, when we first rolled it out, it was slow. It doesn't roll out immediately, but we began our first efforts at the end of I want to say September of 2019 is when we had our first class. It took a little while to catch up. So it's been since then.
Wow, that's fabulous. Thank you very much.
Thanks, David. I have just a couple of questions. First, about privacy and system entanglement. If the folks are not being arrested on the first or second charge, how are you letting? What are the privacy issues or the policy issues in letting behavioral health and the public defender know about this person, even though they're not being arrested or charged?
That's a great question, but let me correct or modify something. They are being arrested, in that we don't control what the law enforcement agencies do. We've told them about our policy, and in general, with the law, I think the different agencies have taken different approaches. I think in general, San Jose's approach and most others has been, their view is like, well, we don't know what number of arrests they're on. So when we see someone who's breaking the law, we're gonna arrest them. And by arrest, I mean literally stop them, like an arrest, and then investigate it enough to know whether they're going to charge them. And then usually they're going to just cite and release them, because as you know, our jail is not, we're not going to book someone for a recreational drug charge. So that's the moment it happens. They then send us the police report as they would normally. Let me be clear, the police report is usually the one little yellow sheet with the facts on it. These are not like deep investigations. Mm-hmm. So, and we did work with county council. Our view is, well, now, we got this report. We could either file it or not file it. But upon deciding not to file it, we have to notify the defendant, because otherwise they end up showing up in court, which we didn't want to happen, especially during COVID. But we just didn't want to happen at all. We didn't want thousands of people just showing up at the court and waiting all day. And that's when we let we kind of let public defender and behavioral health, because those are sort of public events. But that's all we let them know. And that's the last we hear of it, unless, of course, they're one of that 5% that have 3 or more charges within the period.
Got it. Thank you. And my other question is really just about the the scale, the 14,000 number that are diverted, is that 90% of all cases? Is it 5%? What's the total?
I don't 100% know the answer, but I basically know the answer because we did this beforehand and modeled it on the data we had up until that point, and this should be about 95% of all the narcotics cases that we were treating, or the possessory, the misdemeanor narcotics cases we were filing. And just as a reminder, in California, the only felonies that are narcotics cases would be sales cases or other aggravated cases. But so basically all the personal use cases, about 95% of it.
Got it. Thank you so much. I appreciate it. Back to you, Casey.
Thank you, Supervisor. Next, we will hear from the Office of Pretrial Services. Let me just make sure that we have Matt on this call. Oh, there he is.
Sorry about
Back.
that.
No
Thank you.
problem.
Yes, so our primary goal is to fill the positions that the board supported us in being able to receive, and that enables us to take on the clients that are being released from jail and to screen those clients around the clock. So that's our primary goal. We are really working closely with ESA on the recruitments, meeting every week. Also, we are receiving the clients that Mr. Angel referred to. We have 3 different diversion programs right now. There's pre-filing diversion, misdemeanor judicial diversion, aka post-filing diversion, and AB 1810, incompetent to stand trial diversion. I'd say those are our primary efforts. The others are kind of miscellaneous because we're closely monitoring the jail population and the different ways that people can be released. And sometimes they can be released sooner through some business process improvements.
Thank you very much, Matt. I don't have any questions on your report, and it looks like Supervisor Wasserman is shaking his head. Thank you.
Thank you, Matt. Next, we'll hear from the Office of the Public Defender.
Good morning. Thank you, Casey. First of all, I really am pleased to hear David reporting out on the DA's drug policy. It's really a pretty radical policy and very progressive, and we are delighted to be a part of that. In the early 90s, the vast majority of public defender cases were misdemeanor under the influence charges and felony possessions of a very low level amount of drugs. So this is a radical departure from how these cases used to be dealt with, and their acknowledgement of it as a public health issue rather than a criminal legal issue is very forward thinking. So as far as what we're up to, I think it sort of goes without saying that the primary mission of our office is to work toward alternatives to incarceration, and to that end, we do it every day, all day long, at arraignment and at pretrial, and really we do it better than we ever have because of our early representation efforts. We're able to provide courts with more information earlier in order to effectuate safe release plans back into the community. Also, we spend a lot of time petitioning the court for mental health diversion and all of the other types of diversion that have been mentioned. And one thing specifically I wanted to mention that PAR is kind of working toward, and this segues some with what David had to say about bench warrants being issued, is bench warrants have been a problem for a long time. And if someone misses court, and they miss court for a variety of reasons, bench warrants are issued by the judge, and those then can result in arrests and incarceration. And if a person misses, and lots of people do miss, it's very difficult to get back on calendar. You have to get an okay from the judge, and then you have to file it with the clerk's office. And so one idea our PAR supervisor had, Carly Ware, was to work with the court to try and create some sort of portal like you use when you check in for your flight on Southwest. So if you missed court, you go in, and because of the reduced clerk's office hours, it's hard to get in, even if you can get your form filled out. So this would allow kind of using the court's portal for a person to get back on calendar, which would reduce the number of bench warrants and also then reduce incarceration. So we're kind of excited about that. And part is also, in the meanwhile, taking note in our arraignment department of anyone who misses court, and then contacting those people to work to help them get back on calendar. And we'll do the legwork on that. So that's a significant number of people who will not have bench warrants lurking out there that result in arrests. So happy to answer any questions, and that's my update. Thank you.
Thank you very much, Molly. I appreciate it. And correct me if my memory is wrong, but did we have some issue during the pandemic where people were recorded as not showing up for court dates when the courts were closed or not in session, or were those all postponed?
What happened initially was we shut down in March of 2020, and people had court dates and they just canceled them or continued them, and people didn't really know. It was 60 days from the day they were supposed to be there, but the court agreed not to issue bench warrants at that time because it was so chaotic. So later on, there were some bench warrants issued, but we worked really hard together to notify clients to get back. So it was kept to a minimum, if that answers your question.
Thanks so much. I appreciate it. Supervisor Wasserman, any questions?
No, ma'am, I don't. Thank you, Molly.
All right.
Thank you. Next, we will hear from the Office of the Sheriff.
Good morning, Chair Supervisor Ellenberg and Vice Chair Supervisor Wasserman and the rest of the members of the Public Safety and Justice Committee. I'm Assistant Sheriff David Sepulveda. I'm here with our Administrative Services Director, T. Dang, and Captain Tom Duran. And Captain Tom Duran will be giving our update.
Good morning. So the Sheriff's Office, one of the things that we're doing is we continue to assess our in-custody population for early release programs to include CASU, EMP. One of the things that we've done is we're working with our administrative booking department. We are trying to catch individuals who are being sentenced to turn themselves in. So we're working with them just to kind of finalize some paperwork where basically what it's doing is it's going to advise those individuals who have to go to the main jail to pre-book and schedule a date to turn themselves in. It's giving them information on how to reach out to our programs unit so that we can work with them and actually, instead of them having to turn themselves in, we have them reach out to us, give us their information, and we can see if we can actually get them into our EMP program or our CASU program, one of the early release programs, instead of turning themselves in, which in turn would just increase our population. So we're hoping to have that in play by next week as far as the paperwork and notification process. We are working on all the internal stuff with our rehabilitation officers who are actually doing that sort of work. So we should have that in play by next week. And then in regards to EMP referrals and things like that, that's going well. We're actually, did we lose it?
No,
oh, sorry. In regards to the EMP program itself, we are working with assessing our current population. Our programs unit does have a no-cost MOU with several community colleges where we've been able to bring vocational services into our facilities. Those individuals who are participating in those courses are actually signed up as students for those specific colleges, taking those specific courses. So once they sign up, we're working with that population as well to get them released. One of the issues we were seeing is they don't have housing, so we're working with them to get them housing. We've worked with Evans Lane to secure multiple beds. So as we're releasing people who don't have a case plan, we're creating a case plan. We're referring them to the Office of Reentry Services as well. So part of what we're doing is creating case plans and making sure that individuals that are being released are given the proper tools to succeed once they're released so that they don't get picked back up. We're checking for warrants just to make sure that everything's clear. We're helping them clear their warrants in advance of being released.
And that's the conclusion of our presentation. Thank you.
Thank you. I appreciate the report. Can you say just a little bit more about connecting people to, particularly to housing, or if it's clear that they're going to need some kind of substance use disorder treatment or other services coming out of custody? Are you working with the Office of Supportive Housing or County Behavioral Health, or who are the partners in that work, please?
Yeah, so we're doing all the above. Basically, what we're doing is our rehabilitation officers have contact with all of the above to include Office of Reentry Services. So our case plan includes making sure that whatever services that they need, if they have to report to the Office of Reentry Services once per week to meet with those individuals, that's part of their case plan. The first thing that we're doing is making sure that actually, Evans Lane has probably helped us so much that we're able to provide a lot of the services through Evans Lane to include housing, a bed for 6 months to a year at many times. So that's helped us tremendously for those individuals. And then for others, what we do basically is because we do have office space out of the Office of Reentry Services, we're communicating with Javier and his group to make sure that part of our case plan includes them checking in. So if they're released out in the community into let's say they have a home, but there's other services that they require, that part of the release plan is for them to check in to the Office of Reentry Services 2 to 3 times a week to make sure that they are provided those services and that they show up for those services. And we're also providing classes at the office. The same stuff that we are providing in custody, we're trying to make sure that the colleges are assisting us. And we've worked with the Office of Reentry Services to have classroom space and provide those same classes there for that same population. So because we know when you get released, you may not have the same access to transportation and things like that. And instead of having them go and report to the Office of Reentry Services and then having to go to a community college after, we try to make it a one-stop shop. So it just makes that release process easier for them, and we can work with them, and we're there to answer questions they may have.
Thank you so much. Supervisor Wasserman, do you have any questions?
Thank you. I do have one quick question, if that's okay, before our public speaker. As far as, and I don't know if this is correct through the Sheriff's Department, I'm looking on our list of awesome department heads and speakers, so I'm probably placing this one with the wrong department head. I'm guessing it's Dr. Day, but what I'm interested in at some point is finding out how we're doing on filling our in-custody psychiatric hires of psychiatrists. Would that be more appropriate with Dr. Day, Madam Chair?
I would think so, unless the Assistant Sheriff wants to take that.
Okay.
I think that would be very appropriate with Dr. Day. Thank you.
Okay,
Thank you.
And thank you also, President Wasserman, for pointing out the public speaker. We're going to go through all of the department reports and then hear from the public. Thank you.
Makes sense.
All right.
Next, we will hear from the Office of Reentry Services.
Good morning. I'm Javier Aguirre, the Director of Office of Reentry Services. Just some quick updates that also want to just chime in to what Captain Duran mentioned about the housing piece. Here at the Reentry Resource Center, we have staff from the Office of Supportive Housing. We currently have 10 staff members here that have access to the Office of Supportive Housing HMIS system. For anyone that wants to be screened and assessed for housing, you have to go through the VI SPDAT and then HMIS. So the rehab officer that is stationed at the Reentry Center from the Office of the Sheriff will refer the individual to the Office of Supportive Housing for that assessment. So we do keep track, and there is a countywide effort to kind of look at how many staff members can administer this housing screening and whether it makes sense to do it while they're in the jail or once they've been released. So that's forthcoming. And so just a quick updates on our efforts to support reducing jail bookings. The number one component for us here is the recovery station. So we continue to do outreach to our law enforcement agencies to use the recovery station I'll be reporting to Reentry Network early June on the update on our efforts on the recovery station, and then also looking at what have been our efforts to allow for walk-ins for individuals to access the recovery station. Secondly, in terms of preventing folks returning to the jail, is accessing reentry services. So we've now have community workers stationed at the Hall of Justice Departments 51 and 52, working with clients that may seek reentry services. So now we're equipped to register individuals on site at the courthouse, and then they are able to access and get referrals to our reentry services providers. And then secondly, on preventing folks from going back into the jail is working with our stakeholders to provide effective discharge plans for individuals that are required to do some specific services, and then also encourage individuals in custody to be linked to a client navigator. And then thirdly, is also how we try to prevent people from going into the jail is employment. How do we reduce and prevent barriers from folks to apply to jobs? And that's record clearance. So we're closely working and looking forward to the district attorney's automatic record clearance efforts through the Bend the Arc initiative. So that's something that we're really excited that that's moving along. And then also ensuring that as many individuals seeking record clearance will receive that. And there is a piece in the recommended budget to provide resources for the probation department to reduce the backlog of the record clearance petitions. And then also get some of our clients employed. So with the board approvals to add the unclassified position for the EOC for COVID, my staff has been working closely with clients to help them apply for these county positions. And so we've, I think, supported about 25 individuals, working with them, sitting side by side. And there are times where the application has been denied. My staff works with the client to improve the application, gets resubmitted, and now they're approved. So we should be getting a final number of how many clients have been hired, and hopefully, I think their start date is Monday. So that's something that we're looking forward to. With that, I hear it for some questions or answers.
That's super exciting. It would be nice when we come back, Javier, if you could let us know what the number is and whether this is going to be an ongoing program or if this was a singular opportunity. I hope it's the former. We should certainly be a model second chance hirer.
Absolutely.
Thank you. Supervisor Wasserman.
Thank you, Madam Chair. Director Aguirre, I just wanted to say congratulations again on your 10-year anniversary of reopening the San Jose Reentry Center. I want to tell you on behalf of Vice President Ellenberg and myself how much I know we both enjoyed the in-person and video testimonies from people that you featured. Just so motivating, and just very proud of you and the county. Thank you very much, Madam Chair.
Thank you.
Thank you.
Next, we will hear from the Probation Department.
Good morning, Mariel Caballero on behalf of Chief Laura Garnett. So currently, the Probation Department is employing 4 strategies to support the reduction of the jail population. The first is an on-call screening officer who is available 24/7 to screen probation holds. Admin booking will not authorize a probation hold from a law enforcement agency without approval from probation. So after hours, we screen approximately 20 to 25 holds per week, and more than half are not authorized. Because they don't meet the protocol. Supervising clients on EMP and GPS in the community who are required to complete a jail sentence. As of Friday, we had 85 clients on EMP and 23 on GPS. And our court officers are in numerous courtrooms daily to assist with case conferencing and settlement of cases. And probation utilizes a response grid to guide decisions on responding to violations of probation. This tool provides our probation officers with many other options to address non-compliant behavior to avoid incarceration. That's the end of my report.
Thank you so much. Any questions?
No, ma'am.
All right. Thank you very much. Great report.
And lastly, but certainly not least, we will hear from our partners at the court.
Thank you, Casey. Good morning, Supervisor Wasserman and Supervisor Ellenberg. As you know, the court does not speak to the policy decisions and discussions around reducing the population at the jail, but we certainly can speak to what the court is doing and address Supervisor Ellenberg's question about our inventory. So I am very pleased to announce that the Palo Alto Courthouse did in fact open last week, as we promised the Board of Supervisors back in the fall. That opening occurred on Monday. So that does allow us to service those parts of the population that live in that area. We are having significant shortfalls in two very important areas. At this point, the court has hired 23 employees this year to assist the court with backlogs in the clerk's office and in the courtroom. But we are now stuck with shortages from the sheriff's department. I've gathered some anecdotal information for you. We had a jury last week that waited at the Hall of Justice for over 90 minutes to go to a courtroom because there was not a deputy to staff that courtroom. We had a child on the stand testifying in a sexual molestation case, and that trial was continued today because there was not a deputy to open that courtroom. We had an assault in our clerk's office from a member of the public. The clerk's office pushed the panic button to request assistance from the sheriff's department, but there was no deputy to respond and no one ever responded. Court employees tried to walk that individual out of the building without intervention from the sheriff. So in case you're wondering, we certainly understand the shortages in law enforcement and that COVID has made it difficult to recruit and graduate members from the academy. But as I reported last month, this situation is now dire in that at least 5 courtrooms every day are not able to open and manage the matters that are on our calendars because we have no deputy to staff that courtroom. Likewise, we have a significant shortage of court reporters. That will be the next thing that prevents us from getting our job done. But I did want to report that at least with respect to backlogs in our clerk's office, we have made some new hires and we expect that number to go down. We are now fully open. That Palo Alto makes every courtroom and every building for the court open, if not fully functional, due to the 2 shortages that I've just mentioned. With respect to public safety in housing, I'm very pleased to report that at our downtown Superior Courthouse in the month of June, our court is opening a weekly housing clinic so that parties that are appearing on our unlawful detainer or housing or eviction calendars will be sent upstairs to a courtroom that we are converting into a workshop room where our justice partners will be trying to work every Wednesday in resolving housing issues and eviction issues. And that hasn't started yet, but I very much hope to be able to report that it is operational at our next meeting. Many of you have been asking the court questions about Care Court. And as excited as we are for the governor's interest in mental health, the court is at this point, given our shortage with deputies and court reporters, very interested to see what funding, if any, would accompany that legislation should it in fact pass. We would be very excited for the mental health courts, but we would certainly have to delay anything in the court right now, given our current shortages in staffing and court reporters. That concludes my report for now, unless there are additional questions.
Thank you very much, Judge McGowan. I'll turn first to Supervisor Wasserman, and I have a question as well.
Thank you, Chair Ellenberg. I'm not sure exactly what the right what the right protocol is, Madam Chair. What I just heard from the judge, 3 examples concerned me greatly. I know we have the Sheriff's Department on this committee and in this meeting presently. I guess I would ask if our counsel for this meeting, if we're allowed to have a response of some sort. Those three examples were very concerning and way beyond any situation that I had an idea was occurring.
If I
Yeah,
may just,
Supervisor, no.
I'm sorry,
I
Martha.
apologize.
Kavita?
Yes, I was just responding to the legal question that there's no concern about having a response given at the meeting or subsequently in an off-agenda report should you choose that.
And Supervisor Wasserman, I should own the court's part in this. We did know that opening Palo Alto would create more stress for the Sheriff's Department because we do, of course, require the Sheriff's Department to transport the in-custodies for the Palo Alto calendar. But the shortage has been occurring for months before the opening of Palo Alto.
So I'm back to my, thank you, but I'm back to my initial question. Madam Chair, how would you like to proceed at this moment? Something off agenda, response of some sort now? Give the Sheriff's Office time to respond. What would you like?
Thank you. I'm happy to turn to the Sheriff's Office to see if they'd like to make a response in a moment. Before they do, I want to ask Judge McGowan if the courts are statutorily or somehow legally obligated to work only with the Sheriff's Office to provide courtroom security. I understand the transport issue and things that involve custody, but the Sheriff's Office, as long as I have been on the board, which is now almost a whole 4 years, has had many, many, many funded and unfilled positions. So, and I know that it takes a considerable amount of time to have deputies get through academies and such. I don't want to get over my head in talking about the system, but do you have option departments, law enforcement agencies, or even private security?
We are both statutorily and contractually obligated to receive these services from the Sheriff's Department. But having said that, understanding their shortages, we are investigating what calendars, if any, can be made remote only calendars so that a courtroom is not physically opened. Mm-hmm. And we can prioritize the sort of examples that I've given in my report today.
Right, and I wonder also if the Sheriff's Office, if they are unable to fulfill the terms of the contract, if they could then subcontract essentially that work out. But let's turn and see if the Assistant Sheriff has any comments to make right now.
Right.
Okay. Thank you, Supervisor Ellenberg, for allowing us the time to answer. We are having some shortages with staffing, unfortunately. As you very well know, the pandemic definitely impacted our office greatly. The fact that we were unable to hire for a year and a half has created a huge gap in the services that we're able to provide. We are looking at potential changes in our service model. And at the moment, we are working with County Council to see what we are able to do to see what other type of services we can provide to our courts. So we are looking to see if we're able to contract with a third-party vendor to continue to provide a hybrid type of service model that includes both security and deputies to augment our services while we continue to recruit and hire deputies. But as you may very well know, it does take some time to be able to do something like that. So we are continuing to kind of work with County Council to get an opinion from them as far as what we're able to do, and then also work with our court partner to see if we can come up with a plan that can benefit both of us.
Thank you. And I see that our Chief Operating Officer, Miguel Marquez, wants to weigh in, please.
Yes, thank you. Just wanted to let the
committee know that we are aware of the staffing challenges that the Sheriff's Department has. We're working very closely with them. And, I can't go into detail other than to say that we are also working with our labor partners to try and put in some measures to be able to increase the number of staff at the Sheriff's Department. As you note, Supervisor Ellenberg, they've had funded vacant positions. So, it's not a problem that we only face. It's a problem that's many law enforcement agencies are facing, and we're aware of it, working really well with the Sheriff's Office and again, meeting and conferring with our labor partners to be able to really bring on more people, which I think will fundamentally improve what's going on here.
Thank you so much. And I realize we won't solve all the challenges here today, Judge Miguel, and I'm also thinking about workforce pipeline and development and who we might be talking to about building up a new generation of court reporters. So thank you. Thank you for all of that. And I'm happy to follow up with you on the work piece if you'd like to kind of brainstorm there. Thank you. Thank you to
Supervisor,
all. Yes.
Supervisor Ellenberg, and I understand this is a work in progress, but given the significant impact that this staffing shortage has on the daily operations of the court and the significant impact that this has on our ability to move cases forward on a daily basis, given the significant limitations the court has in the number of departments that are made available for trials. This is really a pressing and urgent issue, and I would like for there to be at least a timeline or at least some mechanism so that we can keep this item in our agenda and for us to remain updated on it. I know how hard it is to prioritize these pressing issues, but again, our courtrooms and our attorneys and our cases and our clients are impacted every day. So I would like this to have some sense of urgency if that's possible.
Thank you so much to the Independent Public Defender's Office. This item number 5 is a standing item for the foreseeable future on the public safety and justice agendas. We're asking each month for the departments to provide a verbal report on efforts both to reduce our custody the size of our custody population and the backlogs of the court. So we will continue to stay at least apprised, and the departments that are actually doing the work will share with us, continue to share, I hope, barriers and challenges so that we can be supportive, as well as to announce successes, which we'll all look forward to as well. Thank you. Are there any, Casey, was that the last one?
That was the last one, Supervisor.
All right, let's go to public speakers. Looks like we have 2. Let's do 2 minutes each, please, Dave. 3, 2 minutes.
Thank you. Next speaker is Jose Valle. I'm unmuting you. Please accept the unmute. You will have 2 minutes to speak. The timer will start when you begin speaking.
Hey, how you doing? This is Jose Valle with Silicon Valley Debug. I just want to remind folks today's daily jail populations is 2,576. So I just encourage all the players that are currently in the meeting today to work collaboratively, creatively, and aggressively so we can meet that 2,000 number once again. I just wanted to also add and comment, I really love the idea or the efforts as far as an alternative to creating a bench warrant if someone misses court. Instead of getting a bench warrant, they could go ahead and reschedule. I love that effort, as well as what can we do to actually increase college attendance, college courses, and release so that folks can continue going to college on the outside. Thank you. Appreciate it.
Next speaker is Christopher Logan. I'm unmuting you. Please accept the unmute. You'll have 2 minutes to speak. The timer will start when you begin speaking.
Thank you very much. My name is Chris Logan. I am a organizing manager for Sacred Heart, our housing action committee. So I work with a lot of individuals who are currently unhoused and formerly unhoused. I do want to center, as Jose pointed out, I appreciate all the conversation around the staff shortages, but we are talking about people, people who are in jail. We do know that jail can be a traumatizing experience. we do know that once people get caught up in the system, and if they're in there for a prolonged period of time, that could greatly decrease their ability to get out of the system and get out of that pattern of behavior. So I just want to make sure that we're centering those people in these conversations. I also want to echo what Supervisor Ellenberg suggested. Maybe it's time to think outside of the box when it comes to staffing, particularly when it comes to the sheriff presence. If there's a way for us to partner or to subcontract that work out, I think that it's time. We're in unprecedented times, and so we need to think creatively, and then also again to think about how do we create a workforce pipeline to make sure that those positions are filled on a consistent basis. Thank you.
Next speaker is Tina Brown. I'm unmuting you. Please accept the unmute. You'll have 2 minutes to speak. The timer will start when you begin speaking.
Good morning. This is Tina Brown. I'm calling in with Silicon Valley Debug. I'm also a system impacted family member with a son that is currently being housed inside the main jail. With all due respect, the efforts made by the stakeholders here sound great, but what I would like to hear is what are the actual numbers? I ask this because when I view the data that's updated daily, it seems to be the number that I regularly see moving up and down, other than the overall population, is the felony sentenced category, which more than likely are backlogged prison transfers. If this is true, this should not be the only way to sufficiently to populate the inhumane jails that we have. Without any number figures given during the reports and considering the court staffing issues, how would anyone know what that number actually is or the progress that is actually being made? Thank you for your time.
And that concludes our request to speak.
Thank you so much. I really want to appreciate the public commenters today. And it was in my notes, and appreciate the reminder that I'll direct to Casey. The verbal narratives are really illustrative. But it's also important for us to hold ourselves to metrics that we can measure. So I would like the future reports to include a very brief written piece that show us the trend of the in-custody population over the previous months since the last PSJC meeting, and a report on the backlog in the courts, so that we do have some metrics. And it sounds like we might want to divide the custody population between pretrial and waiting transfer. All of that makes sense?
Yes, thank you, Supervisor. I've made a note of that, and we'll add that to our legislative file in the months to come.
Thanks so much. And I will formally make that direction a motion.
I'll second that.
Thank you so much. And let's take a vote.
Vice Chairperson Wasserman?
Yes.
Chairperson Ellenberg?
Yes.
Thank you.
All right, thank you very much. We are moving on to item 6, which is the Custody Health Quarterly Medical Grievances Report. And and I'll look to Supervisor Wasserman if you would like to hear the full report. Happy to do that. If you want to go to questions, we can do that as well.
Going to questions is fine with me. Let me just see my notes for a minute if I have anything on the report. I would like to ask the question of Dr. Day as far as our filling of psychiatric positions.
Absolutely.
Through the chair. Thank you.
Please.
Okay, good afternoon, Supervisor Ellenberg and Supervisor Wasserman. And as far as the psychiatrists are concerned, we do have coded positions, 12 coded positions for psychiatrists in particular. And then we have another 7 coded positions for nurse practitioners who augment the psychiatrists, and they do work within their scope for psychiatric patients. Of those 12, we have one vacancy, one true vacancy, where that's a coded position. We keep 5 of those positions vacant because they do offset our traditions behavioral health contract. And so those are intentionally kept vacant to offset that cost for that contract. And then we have 6 positions that are fully staffed by psychiatrists that are county psychiatrists. We are having difficulties, however, with our nurse practitioners, and that's a harder coded position to fill. Of the 7 nurse practitioners that we have currently, we have about 4 vacancies. We have interviewed several times and had very competitive interviews several times, but it's just really hard to get that particular coded position interested in working in custody health services. What we're doing now is we're doing some very tailored recruiting. So we're working to tailor and basically recruit in those areas where folks may have an affinity to work in the jails and work with this population. So we're working to have tailored recruiting, tailored shepherding folks through the process, answering questions. And so we have had some yield that way. A total psychiatrist, 1 true vacancy, 5 that are offset for the tradition contract, and 6 that are fully coded. And then of the nurse practitioners, we have 3 that are currently coded and 4 vacant that we're recruiting for pretty aggressively.
Thank you. Through the chair. Excuse me, if I may, please. Dr. Day, on the nurse practitioners, I heard you say you were having interviews, but it sounded like we're not able to close the deal, even though these people are applying knowing what the job is.
When they're applying, and that's what we're working with as well, supervisor, is that when they apply, they're applying to a code. Sometimes it's not specific that they're applying for custody health because they may believe they're applying for either, picking up at one of the hospitals, for instance, and or somewhere else in the county where they're hiring nurse practitioners. And so a lot of the times we need to make sure that they know where they're interviewing for up front. And so we have had interviews where that has not been clear. However, we do try to, basically continue to shepherd those folks, get their interest, give compelling arguments why this is not, this is a really rewarding job to do. We are now also going to job fairs and presenting at job fairs and have put together brochures so that we could also market the work that we're doing.
Thank you. And I presume, Doctor, that you've made that distinction clear to our ESA department.
Absolutely.
I actually imagine when a person's filling out an application and interviewing, thinking they're working at VMC, and then you say surprise. So I think it's important we get that clarification up front, and I appreciate you doing the specific outreach for the specific position at the job fairs. Thank you very much, Madam Chair.
Thank you.
Thank you so much. Dr. Day, and to your staff, I want to just really express appreciation for this very good and thorough report. It clearly reflects a significant amount of work, not the least of which was the manual analysis of many grievances. I really appreciate the additional analysis that was conducted, the way it was presented. It's really helpful to see for context, given the unique challenges of the last couple of years. I have to say the volume of COVID-related concerns was actually lower than I would have expected. It appears that very few were related to COVID treatment efforts.
Right.
And while I wouldn't ask, I don't think a manual review to categorize COVID versus non-COVID is necessary in future reports. I would appreciate if the future reports continue to show current and prior year volumes for context, again, so that we can see if the grievances are stable, increasing, or decreasing across the major categories. I also noted with appreciation the plan to include a patient experience survey in the future, and I'm wondering if you can share thoughts or plans on timing to launch the survey, frequency of data collection,
Sure.
and then recommended timing to report to this committee.
And very good. And we're at the beginning stages of looking at that, supervisor, and basically looking at that patient experience. Trying to find that right time to do that, simply because we have a moving population. Patients are coming and going every day. So we were looking at maybe upon discharge when they're leaving to do that survey. And typically looking at, like most industries, trying to gauge what that patient's experience was as far as their stay with us in custody health services. Of course, we'll be looking at trends and opportunities for improvement, but we're in the beginning stages of putting together typically what's called a satisfaction survey, but we're looking more of that patient experience, and that patient experience while in the justice setting, as well as experience across different units, looking if there's any differentiation and variance between medical services, mental health services, dental services, and or with particular subsets of nursing and or clinicians, and seeing what the yield is. Typically, it's hard to know how, some of the grievances are basically just complaints, but how those are coming in. I am working with Custody Bureau, however, to look at the entire sort of backdrop of the entire system, and looking at the naming convention, looking at the categories, looking at how they're, what is a methodology of putting these grievances, because these are all manual grievances going into these subcategories. And so we're working on that as well, just to put that an industry standard around healthcare grievances in place. As you know, this is a grievance process that is on the custody health sheriff's side of the house. It's through an IT technology specifically around corrections. And so it served a purpose and it's a point in time, but we are looking at how to basically align that now with more industry standard around healthcare grievance.
Thank you very much appreciated. Do we have public speakers on this item?
We have none, Madam Chair.
All right, we don't need a motion. There's no further direction and receipt of the report. So thank you very much, Dr. J. And we'll move on to item 7, which is care court and mental health roundtable report from Public Defender Molly O'Neill.
Yes, thank you, Chairperson Ellenberg. Our office hosted a mental health roundtable on April 22nd, which had about 40 masked up participants from across the state. And one of the topics that was discussed was care court. Care court, which is Community Assistance, Recovery, and Empowerment Court, was announced by the governor in March of 2022 and designed really to deal with severely mentally ill, likely homeless individuals who are not receiving treatment currently. The plan has some gaps, and it's not fully formed yet. There's a lot of talk in the legal criminal community and in Sacramento about funding gaps. So there's no, as Judge McGowan mentioned, funding specifically identified for the court, and the public defender is named in the legislation to appear with individuals referred to care court, but there's no funding for public defense offices either. So that's certainly a gap. And because really it's dealing with schizophrenic and other psychotic disordered individuals, it might turn out to only serve between 7,000 and 12,000 people, or those are the estimates currently. So that's problematic as well, because we have 162,000 mentally ill homeless people around California, more than that, but at least severely mentally ill. Also, the referral process allows for family members and public guardian and behavioral health folks, but not public defenders and not the court. So the referral process is a little strange. But I am not an expert in this, and I do have one on the screen here. I'd like to, if I could, please introduce a lawyer from my office who is a mental health expert, also helped host the roundtable and was a member of the Department of State Hospitals IST, Incompetent to Stand Trial, work group that met between 2015 and 2017 that developed mental health diversion. So it's my pleasure to introduce Deidre, and Deidre can talk a little more specifically about both care court and our mental health roundtable. Thank you.
Good afternoon, everybody. Thank you. My name's Deidre. I think that to get to it, the care court, the legislature has envisioned it to be a portal, another new portal, such that people in the community that need help can get help. And it's unfortunate that our healthcare policymakers continue to entangle the criminal justice system or our courts in what is obviously a mental health or a healthcare issue. But that's where we're at. It's my understanding that this legislation is going to go forward. And so my recommendation to our community would be that we try and make it the best and most efficient that we can. I have personal family and professional decades experience working with mental illness and disabled adults. And there's nobody that knows the issues better than families, that people that live with mental illness and or adult disabilities. And so this, I applaud, and I think we should as a community embrace those issues that help get services to people. It's unfortunate that we're looking at the court system and we just heard how our courts are having difficulty staffing already. So let me give you just a quick thumbnail of what this proposal is and some ideas that I think we can do locally, and I'll try and keep it to a minute and a half. This is a new way of getting people into the system that we see every day that's suffering in our community. It would be probably more efficient to have our mental health director stand up and embrace this population, because that is the entitlement program. Both Medicare and Medi-Cal look to our county mental health departments to service these people. But entry has always been an issue. One, because these illnesses are in the mind, and two, because oftentimes they're adults with the civil rights freedom to not engage in service. So for those of us who care about our loved ones who are suffering, how do we help them and get the system to respond? And so we have now had a battery of diversions. There's statutory diversions, drug diversions, mental health diversions, there's developmental disability diversion, there's check writing diversions. We have lots of laws on the books. I don't think the problem is the laws, but rather how to get the services to the people that need them most. And it is our community members at NAMI and those of us who live in this community that see the suffering every day. So I would propose that we look at this as an opportunity and try and steer it to direct services. And I think that our county is a very rich, empathetic county with great minds from what I've seen across the state. And I think it's really important that we acknowledge that there are some difficulties in this legislation. The funding component comes from a mental health claim that would get billed through Medi-Cal. And so it's like, they're calling it a treatment plan. And so basically the process would be, according to what's written, is say a neighbor thinks that their community member is languishing in the street. The neighbor fills out a one-page petition and the requirements of the petition are outlined in the statute. Then that petition goes to court under the penalty of perjury, and it goes to a civil court. So this is not a criminal process. This is a civil process. And so in this design, someone would take the petition and their loved one and opine to the criminal court that this person that's ill, they believe the person's ill, they believe the person's ill due to a psychotic diagnosis. And then they would ask the court and the court team to make a treatment plan and encourage the person to engage in this treatment plan. If the treatment plan is approved and the person agrees, then Medi-Cal would be billed for those services. But there is nothing in here for the court structure, for the bailiff that would need to be there that we heard we're having difficulty getting today, for the public defender who is by statute to be there to protect the civil interests of the person, the respondent rather, the person that they think is sick, and then also the support person. There is a statutorily described support person. That could be someone's mother, sister, brother, teacher, public guardian, healthcare worker. It cannot be a member of the public defender's office, so that's an issue. And it cannot be a member of a court, a criminal court or any other court, so that's an issue. But that person, they call the support person, also is funding is not provided, and there's HIPAA issues and privacy medical issues. And so those things are issues that legislative advocates such as myself and others across the state are trying to flesh out in the wording, but it is an opportunity. And this is something that has some big issues for us to overcome. But my opinion is it should be housed in direct services for the people that are sick, and should be used to treat the symptoms that we're seeing in our streets and in our parks every day. There are families that are suffering, trying to help their loved one in the home, keeping an eye on them, not letting them out for fear of getting arrested or harmed. So we need to support those families that are taking care of their family members. And I think we should add in this language, respite care and supportive services for the families. They could also be billed through Medi-Cal and IHSS. These are just ideas, but to wrap it up, it's something that we probably can't stop. We should embrace it and design it to be effective. And we need to have them identify in the governor's budget some kind of trailer funding to go to the necessary services that are not going to be provided for Medi-Cal, Medicare. And that we absolutely need our mental health department to be the champion and the pallbearer of this so we can support them. LA County put $100 million of general fund into issues and responses like this to avoid the arrest, to disentangle the mentally ill. And they had their mental health departments open up a 24-hour crisis chair, long-term supportive, permanent housing, not temporary. And they've really invested in the things that we all could take a loved one to, akin to if your child breaks their arm, you go to the emergency room. If your child is 21 and psychotic, where do you go? You hope to call an 800 number, which is what this county does, and get a referral to an appointment down the road. In the meantime, that bipolar young man or young woman or clinically depressed person will probably end up somehow entangled in the criminal justice system for untreated medical issues that we have yet to have a portal where we just go and take them and get help. That there is a simple fix, but somehow it has been kind of avoided by all of these other massive ideas that involve the courts. And so I could talk for hours. So I will thank you for your time and attention. And I greatly appreciate the work the county government is doing to try and improve the health care of all of our community members. That is what this issue is.
Deidre, thank you so much for that very passionate and I think very well thought out report. I was going to share the CSAC care court call to action at the end of the meeting and announcements, but it feels very appropriate, and I want to make sure that you hear it as well. And I don't know if you're hanging on for the whole meeting, but for the public, beyond my role as chair of this committee, I also sit on the California State Association of Counties Administration of Justice Committee, and CSAC has taken a significant interest in the development of the care court framework, and we've been leading ongoing conversations with the governor's office as well as with both houses of the state legislature. We've convened a joint coalition to draft bill amendments and potential fiscal estimates. And through this work with counties across the state, we've identified 5 priority concerns, which I think are important to share with all here. First is funding, which you mentioned and the public defender mentioned and the judge mentioned. And for us, there's a housing component that's not funded. SB 1338 doesn't include funding for county public defender costs, behavioral health costs, or housing related costs. The governor has said that he intends to sponsor a trailer bill to fund new court costs, but hasn't yet committed to providing funding for the significant county role within care courts. So we are working to estimate the costs associated with care courts and advocate for new state funding to cover those new costs. Second, the bill includes sanctions on counties. which CSAC is strongly opposing, sanctions related to an entirely new program in which counties really lack the authority and the funding, as well as the workforce to implement. If sanctions are preferred by the legislature, the CSAC would suggest that other entities also be subject to sanctions, but really that's not the direction that we want to go. Sanctions clearly exacerbate the issues that public defenders and behavioral health departments and supportive housing departments are already experiencing, including a severe workforce shortage. Third, I'll say a little bit more about housing. While SB 1338 avoids housing mandates, legislators have made it clear that ensuring housing for care court participants is a top priority. So to address these concerns, the CSAC County Coalition is exploring a requirement to prioritize care court participants within any local government unhoused and housing, homeless and housing programs that receive state funding. And this would include programs administered by counties, cities, and continuums of care. I think Molly also touched on eligibility estimates for the number of people eligible for care court vary from 7,000 to 12,000. There's some that I've seen that reach a high above 6 figures statewide. We are pushing for petition eligibility and processes to be refined to align potential resources and timelines with the number of those who could be eligible. We're seeking funding for existing services, additional state support for proven county services that serve or could serve the population identified in SB 1338, including our public guardians and conservators, our assisted outpatient treatment under Laura's Law, peer support specialists, operating and workforce costs, and outreach and engagement efforts to help transition people from the streets into care. I know that many of these priority concerns align with conversations that so many of us have had internally in our county, and I'm hopeful that this powerful coordinated effort of counties as well as the courts and the public defender organizations and others will influence the outcome of the bill. So thank you both for all of your work on this. It really is critical. You're right, Deirdre, that it is going to pass, and we need to make it the most care supportive that it can be. Any other comments from any committee members? Do we have any public speakers?
We do not, Madam Chair.
All right, we do not need a motion. Again, thank you so much to the public defender. And we're going to go to items, where are we, 8 and 9?
Yep.
8 and 9 to hear together. So that's sheriff inmate grievances and the client satisfaction survey on the grievance process.
Morning again, Chair Ellenberg and Vice Chair Wasserman. We do have Captain Michelle Asbin and Lieutenant Joan DeWin to answer any questions with regard to item number 8. And then for item number 9, we have Laura McCabe who will give a presentation.
So just to be clear, we're going to have questions or comments if there are any now on item 8 first, and then you're going to report on item 9?
Whatever your pleasure is, Madam Chair. So we do have our staff available to answer questions for item 8. And then we have a presentation for item 9. If you'd like to hear that first, that's fine.
Okay. No, I don't think I had specific questions on 8. They're sort of blended. So why don't we do the presentation on item 9 first, and then we'll come back to the committee and others for questions, please.
Very good. So we have Laura McCabe who will start the presentation. Laura, are you on?
And I don't have questions.
Sorry, I had. Can you hear me?
Yes. Yes, we can.
I am. Sorry, I'm on remotely. I'm at my son's graduating from college tomorrow, actually.
Congratulations.
So I want. Thank you. So I wanted to, good morning, Supervisors Ellenberg and Wasserman. Thank you for the opportunity to present on this. Thank you, Supervisor Ellenberg, for the referral. As I try to, ready to go. Here we go through the slideshow. Can you see my screen now?
Yes.
Is it sharing? Okay, great. Thank
Yes.
you. So we're very happy to be able to, I'm very happy to be able to present on this. This request was, it's been about a year since this request was first made. And we, since then, have been developing a survey, developing a format for how to present the survey. In the meantime, tablets became available, which became another source for providing the survey and ensuring that we're able to gain access throughout both facilities. So for this survey, this is a voluntary survey. Respondents self-selected. The survey was open to all. It was advertised through the inmate information channel, both at the beginning of the survey and halfway through. It was open for 38 days, and it was available in 3 languages. So the first thing I wanted to share with you is a profile of the respondents. We ended up receiving 110 responses. 63 were from the main jail, 39 were from Elmwood Men's, and 8 were from Elmwood Women's. 100 of the surveys were filed through the tablet, and 10 were filed using the paper system. And 1 was actually filed even using the Vietnamese paper system, which I was very happy to see that our advertising, which was done in 3 languages, was successful enough for us to be able to receive that survey. We did have broad representation across the housing units. That was the reason we did ask the inmates, we did ask the respondents, we did ask the survey people to respond with their housing unit, and that was the purpose, was to ensure we had broad representation across the spectrum and to determine if we had needed to do targeted advertising, which we ended up not having to do because we did have broad representation. So we did ask about the respondent's length of stay, and although this was not used within as a data measure itself, it was used later on in order to for comparison with other data. So as you can see from this chart, we have 31% of the respondents who reported they've been incarcerated for 6 months to 2 years. A nearly equal number of participants indicated being incarcerated between 1 to 6 months with 24% and 2 to 5 years with 23%. And similarly, we had a nearly equal number of participants who indicated being incarcerated for less than a month or 5 years and longer at 12% each. So an important aspect for us to examine, particularly from the Sheriff's Office, is to ensure that people have access to the system. And that means knowing about the system as well as having the capacity to utilize it. So, so the survey provide statements in which respondents were able to strongly agree, be neutral, disagree, or strongly disagree with the statement. And so what I wanted to share here is, in particular, these knowledge statements. I understand how to file a grievance, and 3 respondents either disagreed or strongly disagreed with that. Oops, I have a typo here apparently. 3 respondents disagreed or strongly disagreed with that, and that is important because it means that they're saying that they don't know, they don't understand how to file a grievance. And then the statement, I know I can file a grievance on the tablet. 4 respondents disagreed or strongly disagreed with that statement. As far as capacity, we did have a statement, I need help with writing a grievance or reading the response, and we had 11 respondents who agreed or strongly agreed with that statement. Now, we don't have the ability to compare that with say, for example, knowledge of whether they're cognitively disabled or have language barriers. But this is what we have is what the respondents presented to us. And so 11 respondents agreed or strongly agreed with the statement. When asked about filing a grievance and the response time, we asked how often do you normally file a grievance? And as you can see, for the categories that received the most responses were once or twice every 6 months and once or twice a month. We also asked what their response time was from the last grievance they filed. And so we had 32% of the respondents indicated it was 15 to 30 days. 26% responded 31 days or longer. 18% responded 7 to 14 days, and 12% responded 7 to 14 days, and 12 responded 0 to 6 days. Now, as you're aware, the grievance unit strives to make the responses within 30 days. We do have 26% who responded 31 days or longer, but again, we didn't go back to these particular inmates to ask them more questions. However, I did note that 88% of these 26 respondents continued to file grievances. So it didn't seem to prevent them from using the system that they perceived. This was their perception. Their perception was that it took 31 days or longer. But that perception still did not stop them from using the system. So in particular, when discussing this survey, there was an interest in understanding why individuals do not file a grievance. And so there was a free response box that asked specifically, what are your reasons for not, if you have not filed a grievance in the last 6 months, why have you not filed a grievance? And so 12% indicated, 12 of the respondents indicated some sort of system distrust. And when I categorized their free responses, indicated some sort of system distrust. 8 had other comments that were unrelated to the conversation or not responsive. It's not unusual when you have these types of free responses for respondents to go off on tangents that do not relate. So those fall into that other category. 6 indicated they had nothing to complain about. 3 indicated fear of retaliation, but it should be noted that 2 of the 3 who indicated fear of retaliation have filed agreements in the past 6 months. So it did not seem to deter them from using the system. And 3 indicated a lack of knowledge or skill. 1 in particular noted a language barrier. So we took a look at from the respondent's perspective, we tried to examine the quality of their response. So we presented statements about their response and asked them to rate the statements as strongly agree, neutral, disagree, or strongly disagree. And the statements that we had were, if the response I received matched the issue that I presented in the grievance. And then it resolved the issue, and it was considered fair. The response was considered fair. And as you can see from this, pretty much the graphs are very similar for all of these, with most of the responses falling in the disagree and strongly disagree categories. And then I took a look further at those individuals. So individuals had the option of, you didn't have to do all 3. They were 3 separate statements. And so I took a look at those individuals who responded to all three statements and did not use the neutral category, because that meant we didn't have a response either way on that really. So we looked at whether they strongly agreed and agreed, or disagreed and strongly disagreed. And when thinking about how to describe these and put them together, I really took a look at here's the matching the issue statement, resolving the issue statement, and is it fair? I took a look at how those correlate. And so this diagram really sort of seems to describe that. This category number one would be an ideal category in which the response they received from their perspective matched the issue they presented. The response resolved the issue, and the respondent considered the response fair. So, and then similarly, category two would be the response matched the issue, it resolved the issue, but I didn't think the response was fair. Category three, the response matches the issue, it was fair, the response was fair, but it didn't resolve the issue. So in taking a look at, so I took those 64 respondents who fell into that category where they responded to all three and they had strongly agree, disagree, and strongly disagree, and categorized all of their responses so into these different issue areas. So here's the area, the ideal area, where the response matched the issue, the response resolved the issue, and the response was fair. From my perspective, if the response matched to the issue, that meant the grievance unit understood, and that gives them a thumbs up. They understood, they were able to respond appropriately, they get a green thumbs up. The respondent, if it resolved the issue and the response was fair, green thumbs up. And so in this case, we had 12 of those 64 who fell into that, the number matches the response category. The highest number is, so then in this one would be this yellow thumbs up, this yellow, this okay sign, that's if you get one or the other. If you get, it resolves the issue or it's fair, because it can resolve, maybe it doesn't resolve the issue, but you thought the response was fair because it's not something that the grievance unit can solve. It was something unrelated. But so you thought the response was fair even though it didn't resolve your issue. And then the thumbs down is if something like this, where category number 8 here, where it doesn't fit anywhere, then you'd get thumbs down. So the majority of the respondents, 43, fell into this category down here, where it was 2 thumbs down. However, we did not have the opportunity to go back and take a look at the grievances that were actually filed to see if it was an issue that the grievance unit has any control over. The grievance unit will get grievances about a court case or about something related to the facility that is innate to the facility and can't be changed. They'll get grievances about things about what's happening on the outside that the grievance unit has no control over. And in some cases, the grievance unit is just a place to dig in and somebody to listen. Someone's listening out there. But anyway, so we weren't able to take a look at the grievances to determine if they, why they fell into this category. We didn't look any further into that. But there were a number of another who fell into all these other categories as well, where they thought the response was fair, where the issue wasn't resolved, but they did think the response was fair. The issue was resolved in spite of the fact that the grievance unit, the grievance unit response didn't match. Somehow it was resolved by, they'll file in multiple places. Maybe it was the grievance unit knew it was already completed because the facility had already taken care of it. So, so we have a number who fell into these other categories.
I love this graphic. I just want to ask you to move a little bit more quickly through the presentation, but this is really very well designed and presented. But go ahead.
Thank you. Okay, so the last thing, this is actually the last slide. So we briefly looked at the appeals process, because beyond the grievance process, you can file, the respondents could file an appeal to their grievance. So we took a look at first the knowledge about the ability to file an appeal. And we did have some who disagreed and strongly disagreed that they knew about, that they were able to file an appeal, these 16% right here. And that's a more knowledge about the system issue. Then the response from the appeal was fair. We had a number many who did not, who strongly disagreed that the appeal was fair. And then we did take a look. I did have a free response box along with that and the grievance, and the responses for both the grievances and the appeals were pretty similar. They thought the response was dismissive of the issue, or maybe there was some bias built into the system. And quite a few complained about the impersonal nature of the process, maybe even particular with it being done on tablets now. It feels much more impersonal because you get your electronic response instead of a handwritten one. So anyway, I wondered if you had any questions. That is the end of my presentation.
Thank you very much. I really do appreciate the presentation. I have some questions, but I'll turn first to President Wasserman and see if you have any.
Thank you. And then I see we have a member of the public want to speak as well. I just want to say thank you, Laura. It's, your passion is obvious, and your graphs were incredibly detailed. The more I looked, the more I saw. I appreciate all the information I received, Chair Ellenberg, but I do not have any further questions on the findings. I think her findings were very, very well detailed and shared with this committee.
Thank you.
Welcome.
All right, thank you so much. I want to also extend appreciation to the staff for the detailed report and commend the grievances unit for successfly scaling up in response to the significant increase in grievances that came along with tablet implementation, while maintaining I think a very decent response of timeline response. I also appreciated Custody Health's breakdown showing that a small number of women account for a large number of grievances. And that to some degree explains the differences between Elmwood Women's and other jails in some of the presentation. But I was still, in the number 8, I was still puzzled by the gender differences in other areas. And most notably, I was wondering why the medical grievances for Elmwood Women's on slide 11, that was which we didn't present today, had an inverse trend to Main Jail and Elmwood Men. I'm wondering if anyone from Sheriff's Office or Custody Health can comment on what the context is of this pattern.
We have our team from the grievance unit on, so they will answer, Captain Asman or Lieutenant Nguyen.
Thank you, Supervisor Ellenberg, for that question. I will defer that question to Lieutenant Nguyen, who does oversee the day-to-day operations of our grievance unit.
Good afternoon, supervisors and the board. On slide 11, we did notice that during the quarter, we were tasked with, the Omicron surge in January at the height of the surge, with 285 inmates positive for C19. At the tail end of the quarter, we had 2 inmates on March 31st at the end of the quarter with positive for COVID-19. Without looking at the full data, we did see a consistent trend with the amount of COVID-19 positive grievances as it, increases with the positive numbers with the increase of grievances. And then I saw a dip in the March numbers down to 11 medical grievances for CCW. Without having a deep dive into an audit, I don't have the full facts on that one, but I can see that in the subcategories that CCW, the women's facility, it did lower in the care department. So that's what I can see from previous months.
Okay, if we want to dig in a little bit more, we'll take that offline. I would like to know also what has been done or what the plan is to respond to the satisfaction survey results. There clearly was room for improvement in some areas.
Yeah, you're clearly right on that, and I think that what we realized in this particular survey, and this is first of many surveys to come, we're not going to end with one survey. I think we realized we probably need to increase communication with the inmates, specifically regarding the areas where they strongly disagreed. The other piece of it is, and you know, we have onboarded work with Office of Ombuds and others to help us respond to these grievances in a very balanced approach, and to make sure that somebody's looking at us also as to how we respond, to make sure that you know, what we may believe the response is meaningful and responsive. You know, it's good to have others look at that as well, to make sure that you know, we're doing that. So I think those are the two primary things we've taken away from this: is better communication and making sure that inmates understand the system better, and then also having making sure we have a balanced approach on our responses.
Great, and this provides us with a good baseline. I appreciate the acknowledgement and not shying away from areas for improvement. We all absolutely have them every day. I'd like to ask that this presentation be posted on the website or somewhere appropriate, so that the public can access it and be able to review the results. And then over time, as you produce more survey results, there'll be an opportunity to evaluate long-term improvements.
Absolutely, we'll do that.
Thank you very much. Any other comments from members? Sylvia?
No, if that was a motion, Madam Chair, I'm happy to second your motion.
Thank you very much. But we'll hold on the vote for a moment. I'll hear from Sylvia, and then I think we have a public speaker.
Yes, so thank you. No, I just wanted to commend the Sheriff's Office for this survey and undertaking this important work. I know it's not easy to be introspective in our practices and in our approaches, but I think what's evident in the findings is that there is a communication issue and there is the trust issue. And I'm really gratified to hear Assistant Sheriff Sepulveda say that it really is the communication piece. And one thing to keep in mind is that in criminal justice, everything is about process and procedural fairness. And so I think that to the communication piece, while not everybody is going to be happy with the outcome, a lot of people appreciate the process, and they appreciate the information, and they appreciate the efforts. And I say that speaking from experience as well. I mean, the Sheriff's Office is not the only one criticized, right? We get feedback as well about attorneys and attorney practice and competence, and we get complaints always. But in my experience, when people feel that they have been heard, and when they feel that they've gotten a fair shake and are being listened to, that really will see results in terms of like a degree of satisfaction. And it isn't about the result, it's more about the process. And I think that I wanted to convey that to Assistant Sheriff Sepulveda to reinforce his efforts at the communication piece.
Thank you very much.
Yeah.
Not seeing anybody else. Dave, let's go to our public speaker for 2 minutes, please.
The next speaker is, pardon me, Urvish Kumar Mehta. I'm unmuting you. You have 2 minutes to speak. Please go ahead.
Thank you very much to Board of Supervisors, respective county sheriff, as well as the respective members of the commission. I wanted to acknowledge the fact about the grievance report and the presentation. However, what becomes even more important is that when the grievance reports are being filed, what becomes more important is that what is the issue that being resolved upon, because it becomes important that when any grievance report they are being filed and they are being matched with the particular issue, and then the resolution comes out, then it can be considered as a positive response towards what grievance report has been filed, and then as a part of a public safety and justice committee's resolution has been made basis upon what the grievance report is about, and then the narratives are being laid down accordingly that whether the grievance reports being filed are effective manner to respond to certain situation within the jail facility and for the incarcerated people or not. What I also wanted to mention is that the public safety system is built upon the trust. When any particular communities feel that they are treated unfairly and not equitably by law enforcement, it does not increase the trust. In turn, it contributes and decrease the public facility. So filing the grievance reports are important, but when filing the grievance reports and then coming to a conclusion and coming down to the point where public safety and justice system providing the inputs that how the correctional and enforcement are being placed through the law enforcement agency, at that particular point that becomes very important. Filing the grievances are one point, resolving is second, but what is effective is that the productiveness of the grievance report filing and then providing a response and resolution to it in an effective manner by the county. Thank you very much for consideration.
That concludes our requests to speak.
Thank you very much. Item 10 was moved to consent. Item 11 is for announcements from any of the committee members, virtual dais sitters.
Madam Chair, pardon the interruption. We had a motion and a second on items 8 and 9, but there was no vote taken on that.
Thank you so much, Dave. Let's do that now.
Vice Chairperson Wasserman?
Yes.
Chairperson Ellenberg?
Yes.
Thank you.
Thank you so much. Do we have announcements? Not seeing anybody wave at me. In which case, I will adjourn this meeting at 11:46, and we will reconvene on June 9th at 10 a.m. Thank you so much, everybody. Take care.
Thank you.
Thank you, Chair.
Thank you.
See ya. See y'all for budget next week.
Thank you.